Hello, this is Mr. Seymour, and in this lesson we're going to talk about Chapter 5, Civil Rights. This is Sheriff Joe Arpaio. He's the former sheriff of Maricopa County, which includes Phoenix, Arizona. He argued that strong measures were necessary to discourage illegal immigration. He's known for stop and frisk. He also is known for enforcing immigration laws, or having his deputies enforce immigration laws, even though they were not immigration agents. Here, Sheriff Arpaio stands in front of Maricopa County Jail the day that the county's controversial measures went into effect, which basically allowed or required officers to ask suspected illegal immigrants about their immigration status. And of course, a lot of people called it the driving while brown law. Recently, Sheriff Arpaio was convicted of a federal contempt of court charge in regards to that same policy. And President Trump used his presidential power to grant Sheriff Arpaio the first pardon of his administration. Civil liberties are not the same as civil rights. Put another way, civil liberties describe what the government cannot do to us, which is freedoms or negative rights, while civil rights describe how the government needs to protect us from discrimination, which ensures equality, and those are called positive rights. For example, civil liberties include First Amendment free speech rights, Fourth Amendment freedom from unreasonable search and seizure, and Fifth Amendment rights not to self-incriminate or to remain silent. Civil rights are more positive rights, many of which are reinforced by the 1964 Civil Rights Act, not to mention the 13th, 14th, and 15th Amendments. These are laws that protect us from discrimination and are relevant to Equal Protection Clause of the 14th Amendment. The 14th Amendment is the key to civil rights. These are more positive rights, many of which were reinforced by the 1964 Civil Rights Act. They include the right to vote, the right not to be discriminated against in hiring, the right to use public accommodations, for example, to sit at a lunch counter, regardless of race, the right not to be discriminated against in housing, and they're heavily centered on the 13th, 14th, 15th, 19th, and 26th Amendments of the Constitution. Slavery was a part of the American economy from the 1600s until it was abolished by the 13th Amendment in 1865. The system of slavery in the South created a highly unequal society in which African Americans were denied virtually all of their rights. Abolitionists worked to undermine and abolish slavery. Harriet Tubman, who's pictured on the right, was instrumental in the success of the Underground Railroad, which brought countless slaves to freedom. In 1883, the Supreme Court held that Congress did not have the power, as it did in the Civil Rights Act of 1875, to forbid racial discrimination in private businesses. Even after the Emancipation Proclamation during the Civil War, progress was slow. The South legislated against its former slaves. The case of Plessy versus Ferguson in 1896 enshrined the idea of separate but equal, where segregation was officially permitted. Jim Crow laws gave blacks inferior treatment. For example, worse public schools. In the late 19th century and early 20th century, at least until the landmark case of Brown versus Board of Education in 1954, but in actuality even longer than that. So to be disenfranchised is to be denied a right, such as the right to vote. Enfranchisement usually deals with the right to vote. Jim Crow laws disenfranchised blacks, especially from voting. You had poll taxes, which were taxes levied to exercise the right to vote. Grandfather clauses, which were clauses that permitted people the right to vote only if their grandfather had that right, which slaves did not. Literacy tests, which were an exam administered at poll booths testing detailed knowledge of civics, which were usually targeted at black voters. The separate but equal doctrine upheld racial segregation, especially in the South. Native Americans were systematically removed from their land and often eradicated. They were brought to reservations, prevented from voting until 1924. Most treaties that Native Americans signed with the U.S. government were broken or ignored, so Native Americans' rights were denied until at least the 1920s. In the context of Latinos, Latinos have struggled for political and economic equality. They lack political clout, the political clout of African Americans. They tend to vote at a lower rate, and they're more politically diverse. This is Cesar Chavez giving a speech. In the 1960s and 1970s, Cesar Chavez and the United Farm Workers Union successfully organized mostly Mexican-American farm workers, first in California, then in other parts of the country. Here, Chavez is speaking to a group of people in Texas, and you'll notice the sign in Texas, "Si se puede," yes we can. The first wave of Chinese immigrants came during the 1848 gold rush in California. Chinese workers played critical roles in completing the Transcontinental Railroad, but were victims of violence and discrimination. The Chinese Exclusion Act of 1882 especially banned any immigrants from China and sought to prevent any Chinese immigrants already in the United States from becoming citizens. Though the Supreme Court granted automatic citizenship to any American-born children under the 14th Amendment, the United States has officially apologized to Japanese Americans after their internment in World War II, admitting that it was a grave injustice that was motivated by racial prejudice. So, the Chinese basically built the railroads then in the 1880s. They were kicked out. A lot of them went to Mexico. Juarez has a lot of people with Chinese surnames, and the reason for that is because they went over the border because they had to leave the United States. While the view that men need to protect women and that women need to take care of the home and family is in decline, elements of protectionism have guided the Supreme Court's actions as recently as 1961. Women have long been held out of political action, only receiving the right to vote in 1920. Policies preventing women from holding office or owning property were motivated by ideas of protectionism. The riots that took place after police raided the Stonewall Inn in New York City galvanized the gay community and helped propel them into action. Gays and lesbians are the most recent group to struggle for civil rights. Political action began with the Stonewall Rebellion in 1969. Support for gay rights has grown substantially in the 40 years since, but it still has a long way to go. From landlords discriminating against gay and lesbian couples, women suffering sexual harassment in the workplace, to banks ensuring predatory loans to minorities, there are both anecdotal and statistical data that show discrimination continues to exist in our society. While significant progress has been made, discrimination is more common today than most people realize. On average, the EEOC, the Equal Employment Opportunity Commission, files 96,000 cases of employment discrimination each year. Today, the racial divide can best be seen in voting access. African Americans now vote more than any other racial group. Nonetheless, Minority voter turnout is depressed by certain practices and institutions in many states, such as voter ID laws in Texas. States that purge voter records or create barriers for voter registration may not target minority voters, but nonetheless disproportionately impact them. Environmental racism means that minority groups are more likely to live in areas affected by pollution, toxic waste, and chemical sites. The case of public water in Flint, Michigan is instructive. The residents are overwhelmingly poor and they're black. Despite the city's residents reporting that the water was unsafe to drink, the local state government ignored their complaints, and as a result, some 6,000 to 12,000 residents had elevated blood levels and serious health issues due to unsafe water. There's an income gap. 3 times as many Hispanic and black families live below the poverty line as white families. The average white household has more than 6 times the net worth of a typical non-white family. Unemployment rates for black men are twice as high as that of white men. There's a health gap. On every measure of health, there's a large gap between whites and blacks. Whites tend to be more healthy than blacks. These gaps are caused in part by government policies and business decisions. Carefully examine these maps. Look at the relationship between poverty and minority population. How do you think these patterns might affect the politics of civil rights policies aimed at reducing discrimination in the workplace or housing? And this comes from poverty data from the United States Census Bureau, 2014. If you look at Texas has between 18 and 19.9% poverty rates. The U.S. poverty rate is 15.5%. In states that tend to be more white, the poverty rate is lower. In states that have more diversity, the poverty rate is higher. This is percentage of population that is white. The previous slide was the percentage of population that is black. This is the percentage of population that is white. And you'll notice that African American and southern states tend to have more poverty among black people than white people. The greatest disparity between minorities and whites may be in the criminal justice system. Racial profiling means many innocent blacks are subjected to intrusive searches. Tensions between minority communities and the police, as dozens of cases of police shooting unarmed black men have been highly publicized, and that continues even to today. There have been dozens of high-profile cases in many recent years of police officers shooting unarmed black men. Here, Michael Slager, a North Charleston, South Carolina police officer, is shown shooting Walter Scott following a traffic stop for a broken tail light. Recent events in Ferguson, Missouri, Baltimore, Maryland, and Staten Island, New York, among other places, have touched off a nationwide debate about fairness in law enforcement. Do racial inequalities exist in law enforcement? Let's look at what the numbers say. You'll notice that people killed by police in 2015 by race among white people, it's lower than among black people. Okay. Unarmed people killed by police in 2015 by race is, again, you'll notice that black people are much more likely to be killed if they are unarmed by a police officer. The left side is the total, and the white side and the right side, the blue side, is the number of people per million that were killed. So if you look, blacks are twice or three times more likely to be killed than whites. We spoke about lunch counters earlier. This is the famous lunch counter protest. 4 African American college students protested as a whites-only lunch counter in Greensboro, North Carolina, and started the idea of sit-ins. These sit-ins spread throughout the South in 1960 as civil rights activists were able to put pressure through their nonviolent protests on businesses to integrate. Here, a 15-year-old civil rights demonstrator defying an anti-parade ordinance was attacked by a police dog in Birmingham, Alabama on May the 3rd, 1963. The next day, during a meeting at the White House, President Kennedy discussed this photo, which had appeared on the front page of the New York Times. Reaction against this police brutality helped spur Congress and the President to enact civil rights legislation in 1964. Now, your book gives you a civil rights timeline, and it's rather difficult to read on these screens, but I'm going to go over it with you. In May of 1954, the United States Supreme Court ruled that segregated schools were unconstitutional in the case of Brown versus Board of Education. And that's probably the most important case. You have Plessy versus Ferguson, which established, in the 1890s, established the separate but equal clause. And it isn't until 1954 that Brown versus the Board of Education overturns Plessy. On September 9th of 1957, the Federal Civil Rights Act prohibited discrimination. In September 23rd, President Eisenhower sent troops to escort black students into a white school in Little Rock, Arkansas. On July the 2nd, July the 2nd of 1964, President Johnson signed the Civil Rights Act. And in August 6th of 1965, the Federal Voting Rights Act, which prohibited denying anyone the right to vote on the basis of color or race, was passed. Now, in terms of social movements, really, we start the civil rights timeline by looking at Rosa Parks and her refusal to sit in the back of the bus. December 1st, 1955, Rosa Parks is arrested for refusing to move to the back of a bus in Montgomery, Alabama. On February 1st, 1960, black college students will refuse service at a lunch counter in Greensboro, North Carolina, launching the idea of the sit-in. In 1961, on May the 4th, Freedom Riders tested a Supreme Court decision that integrated interstate bus travel, sparking violence against the civil rights activists. In April of 1963, Martin Luther King writes his letter from the Birmingham jail defending nonviolent civil disobedience against unjust laws. In August 28th of 1963, Martin Luther King delivers his I Have a Dream speech at the March on Washington. And in September 15th of 1963, 4 little girls are killed when a Baptist church in Birmingham, Alabama is bombed. On June 21st, 1964, 3 civil rights workers were murdered outside Philadelphia, Mississippi. In 1965, on February 21st, Malcolm X was shot and killed in New York City. On March 7th, 1965, 600 voting rights marchers were attacked by police with clubs and whips on the Edmund Pettus Bridge outside of Selma, Alabama. On March 21st, about 3,200 marchers headed out again on a 4-day march to Montgomery in support of voting rights. And in 1968, on April 4th, 1968, Martin Luther King Jr. was slain in Memphis, Tennessee. The courts were critical of the success of the civil rights movements in the mid-20th century, moving away from the separate but equal doctrine. The court also upheld a number of landmark civil rights laws passed by Congress. but the court has begun to adopt a colorblind position on many civil rights issues, potentially limiting its protections for civil rights going forward. For example, the court dramatically undercut portions of the Voting Rights Act in a recent case in Shelby County versus Holder, and that directly affected Texas and especially the idea of gerrymandering. The Supreme Court has to play an important role in defining and enforcing civil rights, and it recently expanded civil rights protections for women and LGBTs, but it limited protections for minorities. The incremental case-by-case approach, which was espoused by the NAACP and Thurgood Marshall, had a cumulative effect that gave the court substantial legal precedent to overturn the previous 1896 Plessy versus Ferguson decision. You had the NAACP challenging segregation by focusing on all-white law schools, then a series of successful lawsuits that chipped away at the separate but equal clause and the enforcement of separate but equal, and then, of course, the landmark 1954 case of Brown versus the Board of Education applied 14th Amendment protections and the Equal Protection Clause to overturn completely the Plessy versus Ferguson ruling, which was separate but equal. The court has expanded its focus on segregation by considering both de jure segregation as well as de facto segregation. De jure segregation means segregation by law. De facto segregation is segregation by fact. By their very nature, de jure segregation is much easier to handle in terms of the law than de facto, because all you have to do in de jure segregation is, like in the case of Brown versus Board of Education, just change the law. But de facto segregation remains today, and that is by fact or practice. And it's hard to change mindsets. And de facto segregation takes many generations to change the mindsets of people. You could also argue that recent events have demonstrated that the mindset of people, and I would mention Charlottesville, Virginia, as an example, that de facto segregation is still very much in play. The court has also applied disparate impact standards to determine if employment practices have a bad effect on racial groups. Here you have the question of busing. Busing students from one school district to another in the interest of desegregation has been controversial since the 1960s. In 2007, the Supreme Court invalidated voluntary desegregation plans in Louisville and Seattle school districts. In places like Boston, Massachusetts, you had situations where, in order to integrate the schools, you took children from the suburbs and you bused them to the inner city schools, and you took children from the inner city and you bused them to the suburban schools in order to balance the number of black and white students. The court long refused to apply the 14th Amendment's protections to women as they fought for equal rights. The establishment of the intermediate scrutiny test in the 1970s made it harder for states to treat men and women differently. Under the test, states can treat men and women differently only when the unequal treatment is substantially related to an important government objective. While the courts have approved affirmative action practices to help advance women in the workplace, and it has been easier to sue employers for sexual harassment, the court has not taken steps to address the gender pay gap. Now, affirmative action happens when the government, when a business or school or organization takes not just a racial neutral stance, but actually says, in order to accommodate for past violations, we're going to give certain races and genders an advantage in the selection process. There is a substantial difference between women and men's earnings in the United States. What could account for this variation? Well, a lot of people would argue it's called the glass ceiling. How much do you think has to do with the levels of discrimination, and how much does it have to do with the nature of the jobs that men and women take? Women tend to take caregiver type jobs, nursing, teaching, and so forth. But a lot of women now, in fact, young men, you're more likely to have a woman as your boss in the business world now than ever. And at least 50% of the bosses in the business world are women now. So when it comes to the glass ceiling, it has been shattered. However, you have to look at different states and look and see what the ratio of earnings from men to women is. The average is that a woman earns 82.5% of what a man earns. But look at Texas. In Texas, it's 75% or less. Women earn 75% or less of what a man earns. Now, this is the women's rights timeline that I'll go through with you, just as we went through the civil rights timeline. In 1848, the first Women's Rights Convention was held in Seneca Falls, New York. In 1869, the territory of Wyoming gave women the right to vote, and it was the first to give women the right to vote. In 1872, Congress requires equal pay for equal work for federal employees, but this does not apply to the private sector. In 1920, the 19th Amendment gave women the right to vote. In 1963, the Equal Pay Act required equal pay for equal work regardless of whether it was federal or private. Title VII of the Civil Rights Act bars employment and discrimination based on race, sex, and other grounds in 1964. Griswold versus Connecticut is a case that legalizes the use of contraceptives by married couples in 1965. Before that, states could actually forbid married couples from using contraceptives. In 1967, federal affirmative action policies were extended to women by an executive order. In 1972, Title IX of the Education Amendments of 1972 required equal access to programs for men and women in higher education, and this has had a lot to do with why women's sports are now equal to, or sometimes even beyond that of performance of men. In 1973, the case of Roe v. Wade established a constitutional right to abortion. In 1982, 35 states ratified the Equal Rights Amendment passed by Congress from 1971 to 1972, but it was 3 states short of the number needed to be added as an amendment to the Constitution, so the Equal Rights Amendment failed. In 2009, the Lilly Ledbetter Fair Pay Act made it easier to sue for gender-based pay discrimination in both federal and private situations. One question to think about is whether the legal revolution regarding the equal treatment of gays is leading the social revolution on the subject or following it. As former Senator Daniel Patrick Moynihan put it, does culture dictate politics, or does politics dictate culture? Perhaps the most important recent Supreme Court case related to gay rights came in 2015 when the Supreme Court struck down the Federal Defense of Marriage Act as unconstitutional. According to this ruling, the federal government cannot deny gay married couple rights granted by the states. So there's been a dramatic shift in the treatment of gay rights. The court in 1986 ruled that homosexual behavior is not protected by the Constitution. The court first endorsed civil rights for gays in 1996. And then it used substantive due process doctrine to overturn the Texas ban on homosexual relations in the early 2000s and late 1990s. Same-sex marriage was guaranteed by the Supreme Court in 2015. The Civil Rights Act included protections for women as well as racial minorities through the Equal Employment Opportunities Commission. was initially unwilling to consider the cases of gender-based discrimination. The Voter Rights Act eliminated literacy tests and other means used to prevent blacks from voting. Black voter registration increased from 6.7% to 59.8% in 1967 in Mississippi, just within 1 year. As recently as 2013, the Supreme Court struck down part of the 1965 Voting Rights Act, specifically the provision that requires certain southern states to receive pre-clearance from the federal government before making changes to their voting laws. So the foundation for civil rights in the 1960s comes through different legislations. And one is the Civil Rights Act of 1964, the Voting Rights Act of 1965, and the Fair Housing Act of 1968. Here, demonstrators are rallying in support of female workers who had filed a sexual discrimination lawsuit against Walmart. Betty Dukes, the lead plaintiff in the case, and the class of 1.6 million women who worked for Walmart filed a class action suit against Walmart, claiming that Walmart paid more to men than it did to women, and favored men over women when deciding on promotions. In 2011, the Supreme Court ruled in favor of Walmart, saying that women would have to prove discrimination individually rather than a class action lawsuit. Illustrating the progressive nature of the civil rights issue, the subject of gay rights would have been unimaginable to President Truman, Eisenhower, Kennedy in the 1940s, 50s, or 60s. But for President Clinton, it was a big deal. The military had a ban on gay members serving in the military. President Clinton used an executive order to allow gays to serve in the military as long as they did not say they were gay and no one asked them if they were gay, which was called Don't Ask, Don't Tell. Critics say that policy undermined military unit cohesion. On the other side, many critics of the current policy say that at a time when the United States Army is critically short of Arab linguists and at war in an Islamic nation, it cannot dismiss personnel merely for being homosexual. That undermines security. This policy was, the Don't Ask, Don't Tell, was repealed in 2011. Most civil rights attention in the modern executive branch has to do with the diversity of presidential appointments and the use of the bully pulpit to advance civil rights issues, or the lack thereof in the case of the current president. So, civil rights benefited greatly by presidential action. So, President Truman integrated the armed services in 1948. President Eisenhower used the National Guard to enforce a court order to integrate high schools in Little Rock, Arkansas, and John F. Kennedy and Lyndon Baines Johnson used executive orders to establish affirmative action. The controversial Don't Ask, Don't Tell policy of the United States military had prevented gays and lesbians from serving openly in the armed forces. Congress passed the Don't Ask, Don't Tell Repeal Act of 2010, which went into effect in September 20, 2011. Once gays and lesbians in the military did not have to hide their sexual affiliation, they were free to marry in states that permitted same-sex marriage. And of course now same-sex marriage is permitted in all states. Many social indicators of differences between black and whites have narrowed, so a new approach is needed. And this Supreme Court view of colorblind jurisprudence is what we're talking about. The civil rights establishment argues that the movement must continue to fight for equality of opportunity for all by enforcing existing laws and fighting for equality of outcomes by expanding racially targeted affirmative action programs. In other words, we need to move beyond race, and we need to understand that it's important to consider equality on all ends. Consider the philosophy of the Nation of Islam. They oppose integration on the basis that African Americans will never achieve equality in a white-dominated nation. These would be called separatists. This is Abigail Fisher, and she sued the University of Texas over their affirmative action policy. She was also known for talking to reporters outside the Supreme Court after the case was heard in 2016. Eventually, basically, her case is in limbo, and she wanted to go to the University of Texas and was denied entry because they said that her grades weren't good enough. However, she said her grades and her scores on her tests were better than those of her African American and Hispanic peers in this, that were allowed to enter into the school. Eventually, she was denied entry into the University of Texas, and she went on to Louisiana State University, where she got her degree. Multicultural issues. Many states have made English their official language, although the federal government refuses to make it the official language of the country, which this allows states to administer driving tests only in English and could affect education policies. Immigration policy has been central in many recent political debates and has played a prominent role in the 2016 presidential campaign and still maintains a prominent role now with regard to things like DACA. Here you have the Border Patrol, agents detaining undocumented immigrants apprehended near the Mexican border outside McAllen, Texas. Illegal immigration continues to be a hot-button issue in the national, electoral, and legislative process. So let's look at how it works in theory. Civil rights cases that involve suspect classification, which would include race, ethnicity, creed, or national origin, are under the strict scrutiny test. You have to ask, is an unequal treatment of individuals justified by a compelling state interest? Either yes or no. If the answer is no, then the discrimination is illegal. If the answer is yes, then is that unequal treatment in the least restrictive environment? If the answer is no, then the discrimination is legal. If the answer is yes, and very few cases meet this standard, then the discrimination is legal. Best example of where your discrimination would be legal comes down to men and women's bathrooms. However, even there, now you've got the issue of LGBT bathrooms, and whether or not the bathroom LGBT people should be or transgender should go to the bathroom of their original gender or of their chosen gender. It gets very complicated. In cases involving sex or gender inequality, is the discriminatory policy substantially related to an important government objective? If the answer is yes, it's not discriminatory. If the answer is no, the discrimination is illegal. If the answer is yes, you have to ask, is the discrimination not substantially broader than it needs to be to protect the important government interest? If the answer is yes, some discrimination based on gender is permitted, but the test is harder to pass than the rational basis test, which applies to gender cases. The answer is no, the discrimination is illegal. But still, where does transgender fall into this? It's very complicated. The rational basis test asks, is the law rationally related to furthering a legitimate government interest? If the answer is no, it's discrimination. If the answer is yes, does the policy avoid arbitrary, capricious, or deliberate discrimination? If the answer is no, the discrimination is illegal. If the answer is yes, this is the easiest hurdle for a law or policy to pass, then the discrimination is legal. The example of the rational basis test is going to be age. So strict scrutiny test is going to be race, creed, or nationality. Intermittent scrutiny test is going to be gender, and rational basis test is going to be age. Now, how it works in practice, how to evaluate a discrimination case. The strict scrutiny case Let's look at case 1. The University of Michigan Law School's holistic race-conscious admissions policy is designed to promote diversity. The court asked, is unequal treatment justified by a compelling state interest? Is the equal treatment the least restrictive option? The court said, okay. In Grutter versus Bollinger in 2003, the court ruled that the state's interest in racial diversity in higher education was a compelling interest, and that its specific admissions policy was narrowly tailored. This was affirmed again in Fisher versus University of Texas, where she lost. In case 2, the University of Michigan's more rigid race-conscious undergraduate admissions policy was designated to promote diversity. The court said, it's not okay. In the same case of Grants versus Bollinger, the court struck down Michigan's undergraduate admissions policy for not being narrowly tailored. As far as an intermediate scrutiny test, this is gender. A California law says that men, but not women, can be guilty of statutory rape. The court asked, is the discriminatory policy substantially related to an important government objective? Is the discrimination not substantially broader than it needs to be to protect important government interests? The court said, in the case of in the first case, discrimination is okay. In the case of Michael M. versus Supreme Court in 1981, the court found that the state had a strong interest in preventing illegitimate pregnancy, and in punishing only the participant who, by nature, suffered few of the consequences of his conduct. You had the case 2 where you had the Virginia Military Institute maintaining a male-only policy. The court said that that was not okay. In the United States versus Virginia in 1996, the court struck down the Virginia Military Institute's policy as a violation of the Equal Protection Clause of the 14th Amendment. Now, for the rational basis test. States have a 21-year-old drinking age that applies equally to men and to women. The court asked, is the law rationally related to furthering a legitimate government interest, and does the policy avoid arbitrary, capricious, or deliberate discrimination? The court said, discrimination is okay. Various state Supreme Courts have upheld these laws on the rational basis that laws may prevent drunk driving among 18 to 20-year-olds. An Oklahoma law allowed 18 to 20-year-old women, but not men, to buy 3.2% beer. The court said that discrimination was not okay. In the case of Craig versus Boren in 1976, the court struck down this law, rejecting the rational basis that Oklahoma had claimed that instead of applying an intermediate scrutiny test. So in other words, you can't say that women are allowed to buy beer where men weren't. Now, voter turnout. Turnout among African Americans has risen steadily over the last 20 years, while turnout of other groups has remained relatively flat. What can account for these trends, and what can state governments do to increase voter turnout? If you look at non-Latino white, voter turnout has gone down since 2004. If you look at black, voter turnout has gone up, but in 2016 it went down. If you look at Latino, it's been relatively flat, going up just a little bit. And if you look at Asian, again, relatively flat, going up just a little bit. Racism. We always talk about what racism is, but let's look at how your book defines or gives examples of racism. Race-related discrimination, as defined by the Equal Employment Opportunity Commission, is racism. You have race and color discrimination. Race discrimination involves treating someone, an applicant or employee, unfavorably because he or she is of a certain race or because of personal characteristics associated with race, such as hair texture, skin color, or certain facial features. Color discrimination involves treating someone unfavorably because of skin color and complexion. Discrimination can occur when the victim and the person who inflicted the discrimination are the same race or color. Racial or color discrimination in work situations. The law forbids discrimination when it comes to any aspect of employment, including hiring, firing, paid jobs, assignments, promotions, layoff, training, fringe benefits, and other term or conditions of employment. Racial and color discrimination and harassment. It is unlawful to harass a person because of that person's race or color. Harassment can include, for example, racial slurs, offensive or derogatory remarks about a person's race or color, or the display of racially offensive symbols. Although the law doesn't prohibit simple teasing, offhand comments or isolated incidents that are not very serious, harassment is illegal when it is so frequent or severe that it creates a hostile or offensive work environment, or when it results in an adverse employment decision, such as the victim being fired or demoted. The harasser can be the victim's supervisor, a supervisor in another area, a coworker, or someone who is not an employee of the employer, such as a client or a customer. Racial and color discrimination in employment policies and practices. An employment policy or practice that applies to everyone regardless of race or color can be illegal if it has negative impacts on the employment of people of a particular race or color and it is not job related and necessary for the operation of the business. In 2016, President Obama designated the historic site of the Stonewall Uprising in New York City as a national monument to honor the LGBTQ equality movement. Here, Dylan Roof is shown after his arrest for shooting and killing 9 people during a prayer service in Charleston, South Carolina. A mourner outside the church was overcome with grief. And these kinds of events continue. We just saw this happen in Charlottesville, Virginia, where you had a man drive through a crowd of people that were protesting, that were actually standing up against protesters who were there that were members of the KKK. Students here are protesting outside the Supreme Court in support of diversity at the University of Texas. And despite the removal of most formal barriers of voting, Latinos are less likely to vote and participate in politics than whites, blacks, and Asian Americans. Latino advocacy groups like Mi Familia Vota work to engage and register voters in their local communities to improve the Latino voting record. And that ends this week's notes.